It's the appointed time. We have a quorum. Let's start the 16th meeting. It's the same papers. We welcome the government officials joining us for this meeting. At the last meeting, we were at clause 93. So let's continue with that clause. In the reference table under major policy matters, this is item 10A. We will continue with the questions and answers. Mr. Kitson Yang. Thank you, Chairman. Just then, the Secretary for Security kept saying he wanted absconders to return to Hong Kong to turn themselves in. I think that will be very unlikely. Still, there is this chance we cancel absconders' passports and they decide to surrender themselves. What mechanism is there to let those absconders return to Hong Kong? The HKSL passport can be used as a travel document. There's also a certificate of identity that can also serve as a travel document. So why just cancel the passport but not the document of identity? What's the thinking behind it? Now, with a passport, people can travel overseas. For people coming back to Hong Kong, we can issue a one-off entry certificate. This applies to people who have lost their passport while traveling overseas. So that's a one-off option. Deputy Secretary. Thank you, Chairman. The document of identity is different from passports. The document of identity can be revoked anytime, so we don't have to spell that out in the bill. Dr. Kennedy Wong. Thank you, Chairman. Clause 93. Cancelling absconders' passports. 93 subclause 2. Once the cancellation is made, the Director of Immigration can take possession of the passport, but there is nothing in the clause to preclude another application, a fresh application for an HKSL passport. Of course, the Director of Immigration has the power to deny the passport in that case, but the applicant can appeal the decision. So under clause 93, will the government consider having provisions precluding absconders from applying for a new passport after their old one is cancelled? Now, a question about the benefits for absconders who have their passports cancelled. In U.S., the passport can be revoked, cancelled due to a criminal offense. There can be arrest warrants. Those can happen in the U.S. U.S. laws can also suspend benefits for absconders, and they cover social insurance. Media reports suggest some absconders try to obtain the consumption vouchers and use our public housing resources. But let's look at U.S. laws. There's a section on suspending or canceling those benefits. Will the government in Hong Kong consider following suit? Now, on Dr. Wong's point about denying further applications, we will consider this option. On benefits, for monetary benefits, Clause 87 deals with those situations, and this means prohibition on providing funds or other forms of financial benefits In other cases, such as housing, we have existing administrative measures to deal with that. Mr. Jeffrey Lam. National security is the first priority. For someone in breach of or suspected to be in breach of national security laws, it would be wrong to let these people get off the hook easily. Granting bail for a surety of a few tens of thousands of dollars is not stringent enough. It's necessary to take back people's passports. In that case, you don't even have to cancel the passport. But we have seen cases where the offense seems mild, but then the suspect take the passport and they flee. We cannot do anything about people who have already fled. It's too late to do anything. But what will we do in the future? So I reiterate my point. Let's be more stringent. Let's take those people's passport. But now that we're talking about cancellation, how can absconders come back without their passport? That is, after the passport is cancelled. Just then, the government said those people could come back by other means. But absconders flee not just on vacation, they flee for good. And we don't know where absconders are. They may have gone into hiding. Some absconders may still be in Hong Kong. Others have fled overseas. But some absconders continue to collude with foreign forces. They stay in those overseas countries. For overstayers, people without a valid travel document, there's no reason for overseas countries to let those people stay there. I want to reiterate this point. How do we fix this? How do we get external foreign authorities to work with us? After all, this is an issue, a common problem that all countries and places that respect the rule of law should address. Under Article 43 of the National Security Law, there's a provision on taking the passport of suspects. But there are shameless people. There were such cases. These people lied to the court, they took their passport, and then they fled. This provision here on cancellation of passport is the way to deal with shameless suspects. And this is the spirit of this provision. Now, some external places harbor absconders. What we can do is to cancel these people's passports. And then when you look at the overseas places, those places harbor those absconders or do anything to assist those absconders. We can all see what those places are doing.
Mr. Lai Tung-kwok, thank you, Chairman. I fully agree with Dr. Kennedy Wong's comments. We have to send a very, very clear message to the absconders. The absconders are very unlikely to reapply for a passport during the specified period. But we have to send a very clear message to the absconders. So I very much agree with Dr. Kennedy Wong's suggestion. We should add a sentence that no application can be made during the material time. That will solve the issue, rather than amending the other ordinance concerning the passports. Secretary, we have heard Mr. Lai Tung-kwok's suggestion. We will consider it. Mr. Chan Shih-hung, Chairman, I would like to follow up on Mrs. Regina Ip and Mr. Lai Tong Kwok's question concerning subclause 3 under clause 93. According to the response of the administration, we want no misunderstanding that there is an appeal opportunity for people who have their passports cancelled under this clause. So I've made reference to other ordinances. It seems that it may cause confusion. That the appeal mechanism mentioned under section 10 brackets 1 of the passport ordinance refer to a decision made by the immigration director. But that's not the case. The scenario where passports are cancelled under this clause is initiated by the Security Bureau. Now, what if I don't apply for leave to appeal under section 10 brackets 1 of the passports ordinance? Can I apply for leave to appeal under this clause? That hasn't been spelled out in this clause. Ms. Daphne Siu. Thank you, Chairman. 93, subclause 3. Our view is the same. The decision is not to be made by the Immigration Department's director. The revocation stems from the law itself rather than a decision made by the director. So it cannot be packed with the appeal mechanism under the passports ordinance. So can a person file for appeal under this clause? Well, as I mentioned, the cancellation is automatically invoked by this piece of legislation, so no appeal mechanism would apply. It is now my turn. A very simple question following up on Mr. Kisson Yang's question. An absconder overseas, if they answer the calls of conscience and want to surrender themselves, but their passports was cancelled. We don't have a lot of ETOs in certain countries. So can they seek assistance from the PRC embassy or our own offices? Of course, if they want to come back to surrender themselves, they can make contact with us, and we would confirm the arrival time of the flight with the airline companies to allow the person to enter Hong Kong. Mrs. Regina Ip, 93 brackets 3. This clause doesn't carry an extraterritorial effect, so there is no way to prevent the person from reapplying, filing for an appeal, or surrender the passports if a person has absconded. So you are saying a person must not do this or that. This is meaningless. So you can only say that to avoid doubt, no appeal procedures would apply. You should put it like that. Thank you. We have heard a few pieces of views from members. We will consider them in one go. Ms. Carmen Khan. I share the same view with Mrs. Regina Ip. To avoid doubt, we can simply say that the passport ordinance would not apply. So riding on this opportunity, we would like to ask this on behalf of the public. So sometimes you would refer to absconders as fugitives. So under or wanted persons. So are they the same? Even if a person has absconded, it doesn't mean that they are on the wanted list. Security Bureau, Deputy Secretary. For wanted persons, that applies to Section 72, brackets 2(1) under the Magistrates Ordinance. A warrant can be issued against certain persons, and those are persons on the wanted list. So this clause applies to absconders. Even if this mechanism is invoked, it doesn't mean that the person is a wanted person. So there must be a warrant issued against that person, and then the Secretary for Security has to specify a person as a absconder. And then one of the previous measures has been selected. And then the cancellation of report would apply. Ms. Daphne Siu, a simple answer to Ms. Carmen Khan's question. The clause doesn't apply to all wanted persons. A wanted person must be one that is specified by the security chief. So even if a person is a wanted person, not all measures apply to them. So even if a person is specified as an abscondist, it is not necessarily so that all the measures mentioned here apply. So does that mean the person is on a wanted list? That's why all the measures will kick in? Or does it mean that everyone who is an absconder is also a wanted person? Because for a wanted person, there would be a bonus issued against them. Now for absconder, they should be on the wanted list. I invite the Security Bureau to supplement. Allow me. So the first step is to issue a warrant against a person under the Magistrates Ordinance. So I think that's Ms. Carmen Khan's concern, whether these people are also wanted persons. Yes, that is the first step. And then the Secretary for Security may specify them as specified absconders. That's the second step. After that, the Secretary for Security can select a measure to deal with the absconders. That's the third step. Thank you. There being no other question, we move on to Subdivision 3 licenses, Clause 94. Official, please. Thank you, Chairman. Clause 94, grants of licenses. Subclause 1, the Secretary for Security may, on application, grant a license for doing an act prohibited by Section 87, 88, or 89. Section 87 concerning provision of funds, 88 concerning measures on immovable properties, 89 joint ventures and joint businesses. Subclause 2, Clause 94, the Secretary for Security must not grant a license under subsection 1 unless the Secretary for Security is satisfied that in all the circumstances of the case, it is reasonable and necessary and would not be contrary to the interests of national security to do so. Thank you. So according to what the Security Secretary said, this clause would be amended. My explanation this morning was that through grant of licenses, the Secretary for Security may grant special licenses for an act prohibited under Section 87, 88, or 89. So for those provisions, for scenarios where a third party may be affected, I can grant an exemption. Thank you. Question, Mr. Holden Chow. Thank you, Chairman. Clause 94, grant of licenses. The application is on acts prohibited by Section 87, 8, and 9. So I would like to give you a scenario, especially under Section 89. Joint venture. One of your shareholders in your company is an absconder. So, according to our previous discussion, the company may remove the person from the board of directors and continue with the normal operation of the company. So if person B absconded, person A can still operate the company. So that's clear. Now, clause 94, the relevant grants, the grants of relevant licenses. If the daily operation of the company involves handling the assets owned by the absconders within the company, the law-abiding shareholders in the company may want to apply with the Secretary for Security to handle the parts of assets affected in the daily operation. So for those applications, can the shareholders offer suggestions on how to deal with those problematic assets so that the problematic assets would not be deployed? So can suggestions be made by the law-abiding shareholders so that the Secretary for Security can grant approval on those suggestions? Or would you provide directions to the shareholders on what they should do with those assets? I think that is a very likely scenario. So I would like to know in advance what is your thinking. Mr. Chris Tang. Thank you, Mr. Holden Chow. Your understanding is correct. For application of grant of licenses, the applicants would make suggestions on what they are trying to achieve. So they would tell us what they need. So the application would contain the suggestions made by the shareholders, and then you would consider whether you would approve them. That is very convenient. Thank you. Mr. Tommy Chang. When it comes to Section 87, 8, and 9, it involves a lot of business activities, in particular directors. So on the grant of licenses, is there any particular application procedure? Do I simply make a call or write a letter to the Secretary for Security that there is a director or shareholder who has absconded? What is the procedure? I don't think this is a very common situation, but I want to clarify the procedures to assure the business sector. Secretary, there is not a particular procedure. Well, the practice follows a situation where we freeze assets under the ordinances. So application would be made by the affected parties to have the assets unfrozen. So usually letters would be written to me. So under Section 87, 8, or 9, those affected parties would write a letter to the Secretary for Security for consideration. There is not a particular set of procedures. Correct. Mr. Chen Xiuhong. Thank you. So this stems from the discussion we had yesterday, Section 89. Now in Clause 94, the Secretary for Security may, on application, grant a license. So back in Clause clause 89, we mentioned several scenarios. In one scenario, a person has been named an absconder by the Secretary for Security during a material time. But before the specification, investment has been made. So clause 94 allows the Secretary for Security to act on discretion and consider the granting of a license for the third party to deal with the affected assets. So in clause 89, what about a joint venture established after someone has been specified as an absconder? Well, if there is no mentioning of this scenario in clause 89, why do we say in clause 94 that the Secretary for Security may make a decision on these cases? Secretary, I don't think this is a likely scenario. Deputy Secretary, clause 89 is quite explicit. For a joint venture established after a person is named an absconder, that is prohibited. So it is clear. So are there any scenarios which will be caught under clause 94 where licenses may be granted? So we don't have a specific scenario in mind under which license would be granted. So if the scenarios mentioned in 87, 8, and 9 applied, and an application is made for grant of license, we will deal with each case individually. I understand the clause seeks to give flexibility for the Secretary for Security. For any scenario, as long as the Secretary thinks that the application is reasonable and that national security is not being endangered, license may be granted. So I think this is quite flexible already. Next, Mr. Gary Chan, Deputy Chairman. Chairman, the existence of Clause 94, grants of licenses, seeks to protect the third party from the daily operation of their business or the daily life being impacted upon. So I follow the logic. According to Mr. Chris Tang, there is not a set procedure for making application to the security, and there is no mentioning of the time frame within which a license would be granted. So the intent is to mitigate the impact of the law upon innocent parties. So may I suggest shortening the period of time within which the license would be granted? That would be more aligned with your policy intent. So if there is not a set mechanism and not a set time frame for granting approval, it seems that you would render the applicants quite helpless.
Thank you. Let me talk about the legal principle. As members are concerned about the arrangements of the granting of license, making sure that it won't affect third parties. This much is clear in the legal principle. In fact, when a public officer is given a power, the power must be exercised within a reasonable time frame. And if it is not executed within a reasonable time frame, one can apply for a judicial review. So we will do things in a reasonable time frame, but it is hard for us to specify the time frame because there are different situations. I believe what we have right now would ensure that the arrangements are implemented as soon as practicable. Another important principle is that we want to make sure the rights of individuals are protected, especially with property rights. So we will go with these overarching principles, and we have them in mind always, so citizens can rest assured. Secretary for Security, you would like to add something? Let me say this, we do have a mechanism. We would deal with things as they come. And that is what we have always done. Thank you. Let's proceed with Clause 95. Thank you, Chair. Clause 95 relates to provision of false or misleading information or documents for purpose of obtaining licenses. There are two subclauses. In subclause 1, it relates to one knowing that such information is false or misleading. In detail, it is a person who, for the purpose of obtaining a license, makes any statement or provides or produces any information or document that the person knows to be false or misleading in a material particular, commits an offense, and is liable on conviction on indictment to imprisonment for 3 years. In subclause 2, a person who, for the purpose of obtaining a license, recklessly makes any statement or provides or produces any information or document that is false or misleading in a material particular, commits an offense and is liable on conviction on indictment to imprisonment for 3 years. Thank you, Chair. Questions? Dr. Kennedy Wong. Thank you, Chair. Clause 95, the heading of which in both Chinese and English, well, in English it is proficient, or making a statement, so to speak. So that would be an active act. In the Chinese version, it is said that one would provide false or misleading information or documents. So should we include, for example, active omission of some key information? Would it be more comprehensive if we include this element? Because they may not have provided false or misleading information, but they have omitted something deliberately. It's just a suggestion. Thank you, Chair. I think misleading would include the scenario in which omissions, deliberate omissions, are involved. I'll let Mr. Leung supplement my answer. Thank you. In fact, in other ordinances, if a person is to submit a declaration, it is required that the information provided is full and accurate. If the scenario mentioned by the member takes place, it would constitute a breach of the ordinance in the sense that it has not declared fully what is supposed to be declared. All right, if you want to include a declaration, then that's what I will agree with. Thank you. Next, Mr. Stanley. Thank you, Chair. I understand that there are two subclauses. I want to know more about the penalties to be imposed. Sections 71 to 74 of the Criminal Procedure Ordinance relating to the use of false instrument, the penalties can go as high as 14 years. And in Section 75, possession of false instrument, the maximum penalty is 3 years. And we have here, for both situations, the penalties would be 3 years. But these are related to offenses endangering national security. What is the administration's justifications for imposing these relatively low penalties? Thank you. Security Bureau. Thank you, Chair. With the implementation rules in the annexes, there are similar penalties. For example, there are annexes relating to the obtaining of information. When misleading information is provided, there are penalties involved. The fine of $500,000 and an imprisonment term of 3 years. If it is more serious in paragraph 95 brackets 2, if there is malicious intent to omit information or give misleading information, these offenses would attract the same penalties as well as an imprisonment term of 7 years. So the imprisonment term of 3 years here are largely in line with the similar offenses in the implementation rules. Thank you, Chair. Let me add something, Chair. False instrument would relate to another offense. There are different offenses that we can charge the individuals with, and depending on the circumstances, we'll see which offense we would go with. Thank you. Any follow-up? I understand that there are some provisions in the national security law on this. If they are adopting a relatively lenient penalty here, and I think when there are many factors at play, especially with the court playing a role here, why didn't the administration impose harsher penalties? Secretary for Justice, you would like to make some clarifications? Well, the Department of Justice has a right under the Basic Law to play a role in the proceedings, and we would go with the Code of Prosecutions when prosecuting individuals. Wouldn't potential disputes arise? I think it wouldn't be the case, because one would have to consider the circumstances of the case when considering which charge to put. The Department of Justice always has such right under the Basic Law, and this is not even subject to judicial review. Let me clarify this. It would be the Director of Prosecutions who would have the right to put which charge. And in English, it is quite interesting. They have used the word prefer. So which charge is preferred? They have full discretion as to which charge to be put in a case. Thank you. Reverend Pretty Kun. As said earlier, if there are different forms to this, is there really a need for the inclusion of Clause 95? If a declaration will suffice, it will already be binding. So if you have other measures in place, and if there are other offenses that are applicable, for example, those of false instrument, wouldn't that render this provision unnecessary? Let me make a clarification here. A declaration would be one under this clause, saying that the information provided is full or accurate. The application is made under other clauses. regarding false instrument, in some CFA judgments, it is said that if misrepresentations are made, it does not necessarily mean the instrument is false or it is forged. So, depending on the actual circumstances of the case, one would have to make a judgment based on them to see which charge is appropriate. I believe what Reverend Peter Kuhn meant was, since you have included a declaration, and if one has made a false declaration, there would be consequences, and if one has used a false instrument, that would be an offense. If we already have such offenses in existing legislation, would that render Clause 95 invalid? It's not that I'm agreeing with what Reverend Peter Kuhn said. I'm just trying to make it clear what he meant. Thank you, Chair. Let me provide a piece of information here. For the granting of licenses, if one provides false or misleading information, this offense is actually common in other offenses, other ordinances, such as ordinances relating to UN sanctions. There would be similar provisions in those ordinances. Any follow-up? Thank you. If not, we'll proceed with Division 3, Procedure in Legal Actions, General Provisions. The first would be Clause 96. Will the administration please commence scrutiny of Clause 96? Thank you, Chair. Clause 96 relates to application of procedure under Hong Kong national security law to offenses under this ordinance. To avoid doubt, any case in connection with an offense under this ordinance is a case mentioned in Article 41 of the Hong Kong National Security Law, and the procedure under Chapter 4 of the National Security Law applies to such a case. Questions? Ms. Carmen Khan. Thank you. I want to confirm if my understanding is correct. Division 3 relates to procedure in legal actions under the Safeguarding National Security Ordinance. Again, to avoid doubt. Regarding Chapter 4 of the Hong Kong National Security Law, it would be included in the brief such information. Without the consent of the Secretary for Justice, one cannot initiate prosecutions, the bail requirements, and the implementation details, and so on. These would be applicable to all cases under the proposed ordinance. And I think it would show that it is compatible with the national security law. And it is basically to make clear that this is the case and to avoid any doubt that this clause is included. Even if this clause is not included, it does not mean that the procedures would not apply. Is that right? Security Bureau or Department of Justice. Ms. Carmen Khan's understanding is indeed correct. We do not need to really say this for it to take effect, but we have included this for clarity purpose. For example, for the provisions relating to bail, that is, for national security cases, the requirements would apply. And in fact, in a CFA judgment, it is said that it would be applicable to all cases relating to national security. It's not just cases under the national security law. And that much is clear. Even if this provision is not included, that would be the case. Thank you. If there are no other questions, let's proceed with Clause 97. Thank you, Chair. Clause 97 relates to cases concerning national security to be adjudicated by designated judges. 1. If a clause adjudicated by a court is a case concerning national security by virtue of Section 3, brackets 2, brackets B, the case must be adjudicated by a designated judge. 2. Subsection 1 does not limit the application of any other enactment to any case to the extent that the other enactment is not inconsistent with that subsection. Thank you, Chair. Questions? Mr. Letung Kwok. Thank you. My question relates to subclause 2, the English text, the last two words, that subsection. And in Chinese, it would also be that succession. So will that subsection refer to subclause 1 of clause 97? Please proceed. It is because Ms. Kamen Khan raised a similar question earlier when we discussed 94 brackets 4 with the ordinance, and the administration gave an answer then that is in conflict with the approach that they are taking in clause 97. So I just want to clarify this because it did take me some time to really process this. Law Drafting Division. Thank you. That subsection does refer to subsection 1, and in clause 94 it refers to the ordinance. It really depends on the context. I think both are valid. Well, I think you didn't give an answer like such earlier, but I digress. Any follow-up? If not, we'll proceed with Division 4. Oh, excuse me, there are related amendments. The related amendments are amendments to Companies Winding Up and Miscellaneous Provisions Ordinance Chapter 32. And that would be clauses 117 and 118 in the bill. Thank you, Chair. Well, can you please talk about what the amendment is and what you have repealed? Clauses 117 and 118 are amendments to Companies Winding Up and Miscellaneous Provisions Ordinance, particularly sections 181 and 186. For 181, it is that power to stay or restrain proceedings against company. In clause 117, we have added the part for if the action or proceeding relates to a case concerning national security within the meaning of Section 3, brackets 2 of the Safeguarding National Security Ordinance. The reference to and before a winding up order has been made in subsection 1 is to be disregarded in applying that subsection. It is that if a winding up order is initiated during the winding up procedures, the stakeholders can do some acts in A or B, that is to stay the proceedings or restrain the proceedings against the company. And we have made this into section 181 brackets 1. Clause 118 relates to action state on winding up order. We will add a subclause 2 if any action or proceeding relates to a case concerning national security within the meaning section 3, brackets 2 of the Safeguarding National Security Ordinance. Subsection 1 does not prevent the action or proceeding from being proceeded with or commenced against the company. So again, we would renumber the original section as section 186 brackets 1, and we would add the subsection 2, as I said earlier. That is, there will not be an automatic stay on winding up order. If we look at this together with clause 117, if there are proceedings against a company, a petition can be raised by a creditor, and one may ask for the proceedings to be stayed. Because on a winding up order, we do not really have to we can also allow such applications after the winding up order. I thank your clear explanation because these provisions are quite technical, and that would facilitate members' understanding, especially those without legal background. Thank you.
If there are no other questions, Reverend Peter Kuhn, Chairman. 360M. The old provision says without the chief executive's approval. But I don't see the part about leave from the chief executive in the new provision. Ms. Stephanie Siu. Chairman. Reverend Kuhn referred to a different provision. Reverend Kuhn referred to 360M. That's clause 121. We're on clause 117 and 118. I will save my question for later. Thank you. Reverend Kuhn, I'm afraid you have got ahead of yourself. Mr. Holden Chow. The provision looks complicated, so I want to clarify something. So does this mean for winding up proceedings, once we have this legislation in place, the winding up proceedings will not get in the way of proceedings to safeguard national security. So winding up and protecting national security both can proceed in parallel. Is that the case? I want to clarify that. Ms. Stephanie Siu. Thank you, Chairman. Mr. Chow is right. We are on the same page about this. Now, this provision looks complicated, so let me explain this. The current position under sections 181 and 186 of the Companies Ordinance, the current position is this. A company is subject to a winding up application. The application comes in, three kinds of people can apply for a stay or an injunction against such winding up proceedings, the company, creditors, or other parties. So after the winding up proceeding or application comes in, those three kinds of people can apply for a stay. Section 186. Those winding up proceedings will be stayed unless there's a court approval to go ahead. Our current amendment is that for national security cases, under Section 181, suppose someone files a winding up application, the three kinds of people can apply for a stay. But then, under Section 186, the automatic stay will not apply. But those three kinds of people can apply for a stay. Thank you. Ms. Carmen Khan. I thank the DOJ for their explanation. So with these two amendments, we will not have an automatic stay by virtue of Section 186. And that means the national security proceedings will not be subject to a stay. So those cases, national security cases, can go ahead. And we are also trying to prevent people who are being investigated on national security grounds from trying to put a stay on proceedings through this channel. And that's what we are trying to achieve, Ms. Daphne Siu. Indeed, we're trying to exclude the automatic stay. So for national security cases, no more automatic stay after the start of winding up proceedings. Any follow-up questions? No. We come to Division 4. Criminal Procedure, Clause 98. For cases in connection with offenses endangering national security. This division applies to a case in connection with an offense endangering national security regardless of whether the case is also in connection with any other offense. Thank you, Chairman. Questions? If not, we move on to Clause 99. Interpretation. Cap 227 means the Magistrate's Ordinance. Chapter 226 of the Laws of Hong Kong, return date. A return date has the meaning given by Section 70A of Cap 227. Thank you, Chairman. Questions? If not, let's move on. Clause 100. Thank you. Remand during committal proceedings. The requirement in the section for remand not to exceed 8 clear days must be disregarded. So unless the defendant voluntarily gives up the 8-day requirement, otherwise the defendant must be taken to a magistrate every 8 days. So even if there's no change to the arrestee's position and there are no fresh bail applications, this rule is prone to abuse and there will be frequent attempts to move the suspect to the magistrate, and this can give rise to national security risks. Clause 100. What are those notes? Clause 100. In applying Section 79, subsection 1 of Cap 227. You see a box there. It shows under Section 79 there are the provisions. But in the pink box there is deletion and change. We're not amending the current provisions. What looks like deletion and text in color is there to show you the effect of the existing provisions. Clause 100. In applying Section 79, subsection 1 of Cap 227, the requirement in that section for remand not to exceed 8 clear days must be disregarded. That's why we highlight the existing provision of subsection 1. We're deleting something. So after this amendment, you will see the effect of the bill, but we are not removing anything from Cap 227. Why not delete the wording in Cap 227 after this bill is passed? Can we switch on Mr. Ivan Leung's microphone? The Magistrate's Ordinance can also apply to non-national security cases in addition to national security cases. Whereas Division 4 of the bill focuses on the criminal procedure for national security cases. So there are special rules that apply to national security cases. This means we do not amend the magistrate ordinance. Instead, we have special provisions in this bill to apply the special rules to Cap 227. That's why in the box, we apply Clause 100 to Section 79 of the Magistrate Ordinance, and the box shows you the effect of the application of Clause 100 in the bill to Cap 227. We are not amending Cap 227. I take your point. Clause 100 means in a national security case, Section 79 of Cap 227 can be disregarded. I get your point. Why not amend Section 79 of Cap 229 by saying this rule does not apply to national security cases? Or have a special procedure because it's a national security case? In the bill, we have all the provisions applicable to national security cases, and they fall under Division 4. We will have to insert many new items into the magistrate's ordinance if we amend Cap 227 directly, because, say, there's a definition on endangering national security. Making a change to Cap 227 by spelling out the treatment of NS and non-NS cases, that would entail the addition of many cross-references in the interpretation. So we decide to spell out the special procedures in Subdivision 4 of the bill. That would be the better way to go. Mr. Holden Chow. Correct me if I'm wrong. So the drafting is like this. Clause 98 sets out the scope of application. And then we come to committal proceedings in Clause 100. For national security cases, these clauses apply. And then we come to Clause 100. There's a note under Section 100 of Cap 227. The 8-day requirement is removed. Now the requirement is to remand the defendant in a reasonable period. So there is flexibility built into the proposal. Normally, in a committal proceeding, the case goes from a magistrate's court to a high court. The committal proceedings is about determining whether there are enough grounds for moving the case from a magistracy to a high court trial. So now this clause says that as long as it's a national security case, the 8-day rule no longer applies. It just has to be in a reasonable period. As the government said, there have been abuses, and we have to bear in mind the national security risks. But when we say reasonable time, are we opening ourselves to challenges? Can the reasonable period be 2 to 3 weeks instead of 8 days? Will someone challenge this arrangement by saying it's taking too long? We're trying to contrast the new arrangement with the old one. The extension in detention, as we discussed, is 7 plus 7 days, 14 days in total. But will this be an anchor in the government's thinking? Of course, circumstances vary from one committal proceeding to the next. But can we adopt a similar time frame? That's what I want to find out. It's a technical point. Who would take the question, please? Mr. Ivan Leung from the DOJ. Thank you. A magistrate may adjourn a case. What is reasonable will depend on the circumstances. Here we're talking about criminal proceedings that have started. At the sitting, the magistrate considers whether further police investigations are needed, whether the prosecution has its documents ready, whether the defense needs time to look at the prosecution's documents. All these factors will come into play in determining what is a reasonable time period. We will be doing away with the 8-day requirement. But at the committal proceeding, for someone in remand, this person retains the right to apply for bail. Section 9D of the Criminal Procedure Ordinance states that every time a defendant is brought to the magistrate, the defendant has the right to apply for bail. And also, under Cap 221, Section 9J, when a magistrate denies bail, the defendant can apply to the court of first instance for bail. This means it doesn't matter how long the adjournment is from the magistrate, the defendant can apply to the High Court for bail as long as the defendant has the justifications. So we're not impairing the right to apply for bail. Any follow-up questions? Legal advisor. Thank you. To write on Mr. Holden Chow's question, I'm approaching this from a different perspective. The government's response to Mr. Chow has more or less answered my question, but I'm looking for some further elaboration. So it's about the 8 clear day rule. We are removing the 8-day rule. My question has to do with the return day. This may have an impact on the rights of the person whose liberty is deprived. So on the point about proportionality, Clause 100 and Clause 101, there is no disproportionate deprivation of the dependent's rights. I would like some further details from the government on that point. Thank you, Chairman. Clause 100 read together with Clause 101 mean the magistrate acts as the gatekeeper. You have a court as the gatekeeper in this case. The court considers the Basic Law and the Hong Kong Bill of Rights Ordinance on the rights of the individual. We do not think that will cause unreasonable deprivation of personal freedoms. Thank you.
Next member, Dr. Kennedy Wong. Thank you, Chairman. Clause 100 is a very short clause, comprising only 2 sentences. But there are 2 must in the clause. In the Chinese text. So according to the administration, the purpose of this clause is to empower the magistrate to set a reasonable time frame of incarceration without paying heed to the remand not to exceed 8 clear days requirement. So must be disregarded. Can we change the phrase to may be disregarded so that there will not be 2 must in the Chinese text? So the magistrates may disregard the requirements. And also the comma before must in the Chinese text, should we dispense with it? There is no comma in the English text, so why comma in Chinese? Law Drafting Division. Thank you, Chairman. I thank Dr. Kennedy Wong for his view concerning the usage of comma. The second sentence is rather long, so with the comma, we can better convey the meaning of the last sentence. Must be disregarded. The sentence in the middle refer to the requirements, that is, remand not to exceed 8 clear days. So the comma is for separating the two sentences for easy reading. Concerning the existence of two must in the Chinese text, again, we have to highlight the second part of the clause, that is, must be disregarded. So the first must refers to the requirement itself in the Chinese text. Thank you. So according to the administration, the intent is to infer a power upon the magistrates. So I think the two must refer to the same thing. Mr. Ivan Leung, Law Drafting Division. Allow me. Even with the existence of the remand not to exceed 8 clear days requirement, the magistrates can exercise the discretion on whether to remand the defendant. But the 8 days decision is to be exercised by the defendant. In any event, the defendant must be brought before the magistrate in a period not exceeding 8 clear days. So that's why we phrase it as must be disregarded. Thank you. Dr. Lo Wai Kwok. Thank you, Chairman. Just to confirm, the way we are reading the subsequent clauses. For other ordinances, the safeguarding national security ordinance has an impact on other ordinances, and you are representing the impacts on those ordinances with the inclusion of the colored table in the text. So for the white table, there will be amendments to the original ordinances. For the colored boxes, you are just inferring the impact on the original ordinances, how the clauses in this bill will modify the effects of those original ordinances, and you are not making any substantial or actual changes to the ordinances. So I just want to clarify this, and I don't think any response is required. Correct. I had some misunderstanding at first, but I think the way you are presenting it is very clear. Ms. Carmen Kan. Thank you, Chairman. We spent some time on clarifying this clause because the Magistrates' Ordinance, Cap 227, we want to know how Section 79, brackets 1 of Cap 227 will apply after the bill is passed. We are not seeking to replace the entire expression in Section 79, brackets 1. So the administration is simply pointing out the difference in how we should read the original ordinance. So subject to the passage of the bill, how can we have a clear understanding of which parts of the original ordinances should be disregarded. We have a very convenient table in pink now on which parts should be disregarded, but in the future, how should we make easy reference to those parts? I think Mr. Carmen Can's question is, for lawyers, we have no difficulties reading the text, but what about a layman? Well, not just that. The markup copy, I mean the table in pink, will not be included in the final product after passage of the bill. So how should we read that in the future? So I think the best way to do it is, besides clause 100, we should make the relevant amendments to the Magistrates Ordinance Cap 227. That is, for national security cases, you should refer to the Safeguard National Security Ordinance. Lawyers and laymen won't be able to see which parts you are crossing out when national security ordinance applies. So if you refer to clause 100, it may give rise to confusion because we can't see which part should be disregarded in Cap 227. If the relevant amendments are made to Cap 227, it may make life easier for everyone. So do consider my suggestion. Mr. Paul Lam, as explained by my colleague, we did consider that option for achieving that same purpose. We have also considered making relative amendments to the Magistrates Ordinance. But if we select that path, the complexity and the workload would be tremendous. Now we are talking about national security cases. When the case is brought before the court, the case would be heard by a designated judge. I don't believe that the designated judge will not refer to the Safeguarding National Security Ordinance. But we will prepare referencing materials so that after the passage of the law, everyone can see how the law would apply on other ordinances. I don't recommend amending Cap 227 at this point either, but we should consider adding a reference in Cap 227 in the future that one should refer to Section 100 of the Safeguarding National Security Ordinance whenever national security offenses are at stake. I fully agree with you, Chairman. We will find a way to make it easier for the legal profession and the general public to understand how the ordinances should be cross-referenced. Thank you. Ms. Carmen Can, any follow-up questions? Then we move on to Clause 101. Thank you, Chairman. Clause 101, appointments of return day for national security cases. An earlier return day should be appointed for national security cases. Now, subclause 1, subsection 2 applies in place of section 80A brackets 3 of Cap 227. So there is note 2, the pink table. It shows the provision replaced by clause 101 brackets 2 in relation to cases to which the division applies. So please turn to page 90 of the markup copy in the Chinese text. So subclause 2, the return day must not, unless the prosecutor and the accused consent of the magistrate on reasonable cause being shown determines otherwise, be less than 10 days, no more than 28 days from the day on which the return day is appointed. Can we have an explanation, Mr. Ivan Leung? Thank you. The procedure is like this. During the committal process as the magistracy, there may be an adjournment, but when the prosecution is ready to commit the case to the court of first instance, the prosecution would apply with the magistrate to appoint a return day. Following the ordinary criminal procedures, a preliminary inquiry may be conducted. In any event, the magistrate will commit the case to the court of first instance on the return day. Subclause 2, under clause 101, according to the magistrate's ordinance, a return day must be appointed. No further than 6 weeks or 42 days after the application is made. Here we would like to shorten the time frame. A return day must be appointed no more than 28 days from the day on which the application is made. So 6 weeks is shortened to 2 weeks. Thank you. I'm clarifying it for the sake of members here who are not from a legal background. So Ms. Carmen Can. Thank you for inviting the administration to clarify the clause. So a return day would be appointed earlier than usual. So it aligns with the principle that national security cases should be dealt with more expeditiously. Is that the case? Mr. Paul Lam, Ms. Carmen Can is absolutely right. The spirit behind these amendments is that we want to implement Article 42 of the National Security Law. According to Article 42, law enforcement agencies must ensure that national security cases are being dealt with in a timely manner and a fair manner. In our view, under the existing crimes ordinance, it offers too much flexibility for ordinary criminal cases if they are applied to national security cases. So we would like to remove those red tapes in case of national security cases. So this is the ultimate purpose of all these amendments we are talking about. I thank Mr. Paul Lam for his explanation. There being no other questions, we now conclude item 1. My apologies. It is not the time yet. I thought the meeting would end at 12:40. So let's continue. Official, please. Clause 102. Thank you, Chairman. Clause 102, translations of documents. We are doing away with the requirement to have certain documents translated for national security cases. Under the existing ordinances, before committal procedure, the prosecution must provide for the accused the Chinese and English translation of statement of witness or a documentary exhibit. And also it must be duly certified. Now, even if both sides are fluent in English, the magistrates cannot dispense with these requirements. So we are seeking to dispense with these rigid requirements so that only when necessary, the judge may order a translation to be prepared for the documents. So please refer to the notes. So subclause 1, subsection 2 applies in place of section 80B, 2C, and 3 of Cap 227. So please refer to the pink box under clause 103. So subclause 2 of the clause. Unless the magistrate, on application by the accused order, for the purpose of section 80B, brackets 1 of Cap 227, that a statement of a witness or a documentary exhibit of which a copy is served under that section must be accompanied by the following translation. A. If the statement or documentary exhibit is written in a language other than English, an English translation. B. If the statement or documentary exhibit is written in a language other than Chinese, a Chinese translation. The statement or documentary exhibit need not be accompanied by the translation. Subclause 3 of Clause 102, in deciding whether to make an order under subsection 2, the magistrate must consider the need for the case to be handled in a fair and timely manner. Thank you. Thank you. Any questions? We continue with Clause 103. Clause 103, preliminary inquiries dispensed with for national security cases. In preliminary inquiries, the magistrate will have to hear the evidence once, and the defendant has the right to cross-examine the witnesses. Now, the magistrate must consider whether there is sufficient evidence to commit the defendant to the court of first instance. Now, this is a mini trial, and it is taxing on judicial resources. So the judiciary has amended the rules so that not all cases to be committed to the High Court will go through preliminary inquiries. So when the case is committed to the court of first instance, the defendant still has the right to apply for release without trial. Now please refer to Clause 103. Subclause 1. Subsection brackets 2 applies in place of sections 80C, 81, 81A, 82, 83, 84, and 85 of Cap 227. For the relevant sections, please refer to page 92 of the Chinese markup copy, all through to page 99. You can see the effect of this clause on those sessions in Cap 227. Now, page 99, subclause 2 of Clause 103. It goes, when the accused appears or is brought before a magistrate on the return day, A, the prosecutor must, if the requirements of Section 80B, brackets 1 of Cap 227 are satisfied, hand into court the originals of the documents referred to in that section, and B, the magistrate must, after an application is made by or on behalf of the Secretary for Justice, take the action under Section 80C, brackets 4 of Cap 227, and if the accused then pleads not guilty to the charge, the magistrate must order that the accused stand committed for trial in the court of first instance and inform the accused of this fact or cause the accused to be informed of this fact. Subclause 3, accordingly, A, in applying Section 80A of Cap 227, 1, subsections 4C and D of that section must be disregarded, and 2, subsection 4E of that section is to be read as requiring that the magistrate must, on first appointing the return day, inform the accused of the matters mentioned in subsection 4 of this section. You may refer to page 100 of the markup copy for the impact of this clause on Section 80A4.
3括
On 3B, in applying Section 81B of Chapter 227, there are 3 points here. 1, a reference to Section 80C brackets 4 brackets A or 82 brackets 1 of Chapter 227 in subsection 1 of that Section 81B is to be read as a reference to subsection 2B of this section. 2, subsection 1 of that Section 81B is to be read as requiring that the magistrate must inform the accused of the matters mentioned in subsection brackets 4 of this section in the circumstances described in that subsection 1. And 3. The reference to where the accused pleads guilty in proceedings under section 80C in subsection 2A of that section 81B must be disregarded. Next, page 103 of the Chinese version. C. In applying section 85A of chapter 227, a reference to section 80 capital C brackets 4 or 85 brackets 2 of chapter 227 in subsection 1 of that section 85A is to be read as a reference to subsection 2B of this section. Again, please refer to the marked up copy for the changes made. In 104, that page, on D, in applying section 86 of chapter 227, 1. The reference to section 80C brackets 4 of chapter 227 in subsection 1B of that section 86 is to be read as a reference to subsection 2B of this section, and 2. The reference to section 80 capital C brackets 1 of chapter 227 and subsection 1B of that section 86 is to be read as a reference to subsection 2A of this section. Again, please refer to remark 8 for the amended section. On point E, in applying section 33 of the Crimes Ordinance chapter 200, the reference to section 80 capital C brackets 1 of chapter 227 in paragraph A of that section 33 is to be read as a reference to subsection 2A of this section. And again, please refer to the marked up copy to see the amended legislation. F. In applying section 14 of the Criminal Procedure Ordinance chapter 221, the reference to section 80 capital C brackets 4 of chapter 227 in subsection 1A of that section 14 is to be read as a reference to subsection 2B of this section. Please refer to remark 10 or note 10 for the amended legislation. In G, in applying section 16 of chapter 221, the reference to section 80 capital C brackets 4 of chapter 227 in subsection 1 of that section 16 is to be read as the reference to subsection 2B of this section. Please refer to page 108 of the marked up copy. And 2, the reference to section 80 capital C brackets 1 of chapter 227 in subsection 1 of that section 16 is to be read as a reference to subsection 2A of this section. And H, if an application is made under section 77A of the District Court Ordinance chapter 336 for the proceedings to be transferred to the court of first instance, the following must be disregarded in applying that section. 1. The requirement in subsection 4 of that section that the judge may only make an order allowing the application subject to subsection 5 of that section. 2. Subsections 5 and 6 of that section, and 3. The condition in subsection 7 of that section that the accused elects under subsection 5 of that section to have a preliminary inquiry. Lastly, in page 111 of the Chinese version, 4. For the purposes of subsection 3A2 and B2, the matters are that if the accused pleads not guilty to the charge, the court will have the accused committed for trial in the court of first instance, and if the accused pleads guilty to the charge, the court will have the accused committed to the CFI for sentence on that charge. Thank you. Questions? Mr. Tonidze. As said, cases have to be handled in a fair and timely manner, and I believe the provisions are here for that purpose. I'm not sure about the procedures or how the procedures work. Can you elaborate on the existing procedures? Thank you, Mr. Ivan Leung. Thank you. If a committal is to be conducted, the prosecution would ask for a return date to be appointed, and then some documents will be given to the defendant. And you can see that kind of information in ATB. That is essentially all statements and documentary exhibits have to be given to the defendant, and on the return date these will be submitted for the magistrate's reference. So on that day, the magistrate would have to ask the defendant whether they want a preliminary inquiry, and in most cases, the defendants wouldn't want a preliminary inquiry. As I said, a preliminary inquiry would be a mini trial, essentially, and witnesses will be called and exhibits will be submitted. If a preliminary inquiry is not required, the magistrate would commit the case for sentencing in the court of first instance. If the defendant pleads guilty, if the defendant pleads not guilty, the magistrate would commit the case to the CFI for trial. So in this subclause 3 in particular, if a defendant wants a preliminary inquiry, the witnesses will have to be called and the magistrate would have to determine whether there is a prima facie case. And as I said, it would be somewhat equivalent to a mini trial. Let me give an example here. There may be 4 defendants in a particular case. 3 defendants select that a preliminary inquiry is not required, and the 4th defendant asks for a preliminary inquiry is to be held. All defendants would have to wait until the preliminary inquiry is over before the case is committed to the High Court. We can see that there may take a long time. We want to make sure there is a fair trial. Under our approach, if the trial is to be conducted in the form of a jury trial, the defendant will be given a chance at the court of first instance to apply to the judge for discharge without hearing, and this will be discussed in a later cause, and the CFI judge would examine the evidence to see if there is a prima facie case. If there is no prima facie case, the defendant can be discharged, and I believe that would maintain the fairness of the procedure. If a trial is to be conducted with 3 designated judges with the certificate of the secretary, we would think that the trials can be expedited and they should be heard early, and in turn the defendants can plead early. That would expedite the proceedings, but then there are also safeguards to make sure that the trial is conducted in a fair manner. Thank you. Chair, I understand that there will be fairness in the approach taken, but can you talk about perhaps specifically how much time would be required under this approach? It may be hard to say, but you can imagine if a defendant opts for a preliminary inquiry to be held. For example, that case has 10 odd witnesses. The magistrate would have to hold perhaps a 1 month proceeding to have the case heard. For more complex cases, we would probably have 20 or 30 odd witnesses. We will save more time with this approach. Thank you. I have a question. If we are to dispense with preliminary inquiries, what will the role is of the magistrates be? Well, essentially, it's like transferring the case to the district court. It is like Section 2 of Chapter 103. If the Department of Justice applies, the magistrate must ask the defendant to plead right away. So that would be arraignment, so to speak, asking the defendant to make a plea. In that case, can you dispense with the proceedings in the magistrate's courts, since you can ask the defendant to make a plea at the court of first instance anyway? Well, I think that would be the basics of the legal system, because all proceedings are to begin in magistrates' courts. In real life, not all proceedings would have all materials ready from the very beginning. The police may have made an arrest while still conducting an investigation so as to not compromise the investigation, and most likely at least 2 mentions would be required before the case can proceed to the next stage. So we consider it appropriate to have the starting point of magistrates' court maintained. Otherwise, it may cause too much of a burden for the court of first instance. Thank you, Mr. Holden Chow. It is as the administration said, which is very clear. If preliminary inquiries are to be dispensed with, much time would be saved. So I do support the approach taken, and of course we always want national security cases to be handled in an expedited manner. I also want to ask for the arrangements adopted relating to preliminary inquiries to be dispensed with. After all, we are talking about cases relating to national security with the exhibits or witness testimonies. Some sensitive information may be discussed during preliminary inquiries if the defendant opts for a preliminary inquiry to be held. If such information is leaked, it may be inappropriate. Has the administration taken into consideration that this may be the case and that they have implemented such arrangements? Let me just say again that I do thank the administration for providing a very elaborate explanation, and I want to stress that it would not affect the conducting of the committal proceedings, and these procedures are existing procedures that have been running for quite some time. So that's it for what I have to say for now. I await clarifications from the administration. Thank you. Thank you, Mr. Holden Chow. As I said, we do want to expedite the handling of the cases. As for whether there may be early disclosure of sensitive information, I would say that this will be dealt with in clause 105, so member can rest assured. Thank you. Ms. Carmen Khan, according to Section 87, it is said that the people of Hong Kong are entitled to having been heard in a trial in a fair and timely manner. And I think that would apply to all courts, even though such cases would start with magistrates' courts. In the end, whether a jury trial is to be adopted, the case would still be heard by a designated judge or designated judges in accordance with the procedures of the court of first instance. So essentially, preliminary inquiry would just cause delays and not necessarily protecting the interests of defendants, as it will prolong the proceedings. I think this is confirmed through our discussions. Thank you. I think it is just a comment made by Ms. Carmen Khan. Mrs. Regina Ip. Thank you, Chair. We have often received complaints about defendants of national security cases being detained for too long. We have heard some complaints like such many times, and they are very stressed. So how much time do you expect to save with the preliminary inquiries dispensed with? And how can you make sure that the rights to raise a defense by defendants will not be affected? Thank you. Mr. Leung? Thank you, Mrs. Regina Ip, for your questions. Let me say that for Subdivision 4, all of the arrangements implemented are to fulfill the requirement in Article 47 of the National Security Law, and we do want to ensure that cases are heard in a timely manner. Not only is it beneficial to the defendant, it is also beneficial to society in general, because we do want to hear national security cases in an expedited manner, and that will be in the public interest. We also have safeguards in place. We would also have judicial discretion, and that will ensure fairness of court proceedings. Regarding how much time can be saved, as I said earlier, it is hard for us to estimate that. But I can provide some information for preliminary inquiries. Witnesses would have to be called, and that would take time. But not only that, the fixing of dates would also take time. One would have to check the schedules of different parties in order to fix a date. So if preliminary inquiries are dispensed with, we can save much time.
Follow-up questions. Mr. Vernon Locke. A brief comment. Just then, Mrs. Ip mentioned a fair trial. My colleague has explained the court will ensure fairness in the trial, but let's bear in mind we are just doing away with the preliminary inquiries. The case goes from the magistrate's court to the high court. The procedural safeguards are all in place. The procedures at the High Court remain in place so that will not impair the right of the defendant to a fair trial. Thank you. If there are no further questions, let's conclude item 1 on the agenda. We move on to item 2. Members and also to officials, if you have draft amendments, that please submit the draft amendment to the Secretariat by 3 p.m. tomorrow. That's Wednesday. That's by 5 p.m. tomorrow. Any other business? No other business. The meeting is adjourned. Thank you.